This is a terrific evening. Thank you, Dr. Bradley, Dr. Fisher, Megan, and everybody else who put this together. I've already learned a lot. As you heard from my introduction, I come at this from a very different level. I have been representing prisoners for a long time with law students. And so I'm going to talk tonight about the tail end of the criminal justice system, the criminal legal system, as I often refer to it, parole. And I'm going to talk about it quite specifically in New York, and I think it might end up challenging a few of the statistics that Barry mentioned. And I think it will pick up on some of the themes that Doug touched on. So I hope we have a robust Q&A after it's over. So parole release is meant to be a mechanism for recognizing that mistakes, even the worst mistake that a person can make, do not define that person forever. We authorize a few people to represent us in ascertaining when a person has reached that point. But what exactly is that point? When are we satisfied that the mistake has been rectified, or at least that some sort of restitution has been made? When the mistake involves violence, including the death of another, these questions are seen through an acute lens. Typically, 2 or 3 people who were chosen through a political process decide for all of us. The parole release process requires a person to come to terms with what is often the worst moment in their life. When the crime was violent, the sentence is inevitably long. Scholars debate the role of punishment to redress crime. They talk of incapacitation, removing an offender from society, retribution, punishing an offender for conduct that violates social norms as expressed in our criminal law, deterrence, a sanction that provides an incentive that will reduce the likelihood that such conduct will reoccur, or that this particular person will engage in similar conduct again, or rehabilitation, a process that regenerates and allows an offender to reflect on their crime and to develop skills and habits that will ensure that such conduct will not reoccur. Judges, particularly state court judges, who are most often elected and who sentence after conviction of most violent crimes, rarely mention any of these goals at sentencing. Prison is a difficult place to engage in the very challenging work that is necessary to successfully navigate the parole process. People who have actually lived that experience describe a dramatic paradigm shift from the silence and denial that characterizes the conviction process to acceptance of responsibility and remorse that the parole process requires. The shock and immediacy of a violent crime is disorienting and devastating to the offender, to the victim, to the families and friends of both. The criminal prosecution almost never affords time or space for reflection or reconciliation. The American adversarial process creates a presumption of innocence for the accused and strong incentives to minimize or preclude genuine acceptance of responsibility or remorse. It is characterized by the terminology of barter and contract, accusation, denial, negotiation, and deals. If the accused goes to trial, she rarely speaks until sentencing, and then for a very short time, many months after the crime. The criminal adjudication process is overwhelming for all and does little to help anyone understand the conduct. When a person becomes eligible for parole release after conviction of a violent crime, it is almost always after decades of incarceration, at least in New York. Parole boards and statutes do not speak of the goals for punishment. They focus almost exclusively on risk, on the nature of the crime, whether release would deprecate its seriousness, whether there is a risk that the person will reoffend, and whether the person has acquired skills and developed a plan that will maximize the chance of successful reintegration back into society. When the crime of conviction involves violence, particularly loss of life, the parole interview presents the first opportunity to confront these requirements. It is always years and often decades after the conduct that will be examined in detail. In New York, most people convicted of violent crimes have been sentenced to an indeterminate sentence, commonly 15, 20, or 25 years to life. The person becomes eligible for parole at the threshold, fixed number of years they must serve. Most people in prison understand those sentences to create an expectation of release at the date of eligibility, if they do everything they can to maintain a good prison record and to use their time constructively. Many parole commissioners appear to believe that taking a life requires a life sentence. The law provides no guidance about how commissioners should decide at what point within that range a person should be released. Parole is an opaque process, making empirical examination of factors and outcomes impossible. Although parole examiners adopt different approaches, many are appointed by a governor after a career in law enforcement. Few have experience in social work or public defense. All of them focus on the crime, usually the worst moment in a parole applicant's life, or at least the one that the person can never really explain in a way that will negate or mitigate its harm. They ask for explanation, acknowledgement of details and facts, many of which are drawn from isolated statements in pre-sentence reports and sentencing statements which the applicant does not remember or has never seen. There is often little time for the commissioners to consider the person before them or his record. Parole commissioners in New York cover a huge state. Currently, once a person becomes eligible for relief, they are entitled to parole interview every 2 years. Today, the board has a crushing caseload that precludes travel to correctional institutions. People who are incarcerated in Bedford Hills speak to commissioners who are in Manhattan. People in Otisville speak by fiber optics to commissioners in Poughkeepsie. The small television screen on which the commissioners appear make it difficult to see them or to ascertain who is speaking. Commissioners receive a pile of applicant files the morning of each interview day. They often have no more than 15 minutes to review a record that contains decades of work history, educational and programming accomplishments, letters of support from friends and family. The essential inquiry into the crime dominates discussion during a parole interview, particularly when the crime was violent. Acceptance of responsibility requires an ability to recite details of the crime, details that are often hidden in records that have been lost or are unavailable to applicants. Parole specialists solicit the views of the prosecutor, the victim, and the victim's family. The parole applicant is not allowed to see letters or information submitted to the board by these constituents, but must answer questions about them. Direct contact between the convicted and the victim or her family is not possible. Recently, a mechanism known as the Apology Bank has been created in New York, but applicants often do not know about this opportunity. Others lack the language or education to express sincere apology in writing. There is, of course, no requirement that victims read these submissions or in any way for the applicant to know if this occurs. By definition, violent crimes are tragic. Loss of life is irrevocable. Restitution is not possible, but restoration might be. The repeated solicitation of victim views about release without providing any information about rehabilitation of the person who committed the offense, the parole applicant has become, revives the crime, making closure or reconciliation impossible. Victims are entitled to know about the possibility of release. They should also be able to learn about the person the applicant has become. We should create a reciprocal mechanism that allows both the convicted and the victims to move on from the crime. Steps have been taken to reorient and improve this process. In 2011, the New York legislature revised the parole statute in an effort to focus attention on the person sitting before the parole commissioners. The new statute and cases analyzing it require consideration of all statutory factors, including those that focus on rehabilitative efforts and release plans. But it is extremely difficult to examine and understand decades of a person's life in a few minutes. A parole specialist at the correctional institution gathers and summarizes the official file. One of the three commissioners takes the lead at each interview, and the other two often appear to be flipping through files of applicants who will follow. Parole applicants compile detailed packets that document their acceptance of responsibility for the crime, their sincere remorse, and evidence of extensive rehabilitative efforts. There is little or no time for the commissioners to read beyond the table of contents that outlines a carefully created and detailed parole application. It is often left to the applicant to correct misinformation or to point out favorable items. After months of preparation, an invitation by commissioners to identify anything in the file that should be highlighted often leaves the applicant to respond, "Everything is important." The commissioners issue a decision sometimes on the same day that often does little more than recite the statutory factors. Decisions rarely provide any guidance about what would improve the applicant's chances of release at her next hearing. Maintaining hope and motivation in the face of silence is extremely challenging. Budgetary constraints and cuts have eliminated valuable programming. For example, post-secondary education in prison correlates strongly with lower rates of recidivism. In 1994, federal Pell Grants were eliminated for these programs. Private donors and colleges have created innovative programs whose participants have impressively low rates of recidivism, but they are available at very few institutions and to very few people in those institutions. People who are encouraged by commissioners to do more programming worry that they will be unable to demonstrate compliance with that recommendation as they have completed every available program. People who have been released on parole have created model parole preparation programs for long-termers, people who have been in prison for more than 10 years, almost always for a crime of violence, and who are prepared to do the difficult work involved in truly coming to terms with decade-old conduct. Small groups work with facilitators to examine the crime in detail, to describe and accept responsibility for it. When possible, they talk to victims, not of their crimes, but of others, who help them to understand the process from the other side. Applicants write about each aspect of their lives before the crime, what led them to it, factors that contributed, and the damage that they have caused. Participants in these programs describe the deep and profound effect this process has on them. This is a valuable program available to far too few. Understanding who the applicant was at the time of the crime can shed light and provide context. We continue to learn about factors that lead to crime. We know that juveniles do not have the cognitive development or judgment of adults. The law does not excuse their violent crimes, but it now considers those acts and their punishment in a different context. We understand more than we did a generation ago about domestic violence and the damage that cycle can create. The law recognizes affirmative defenses and admits evidence that was inadmissible when people who remain in prison were convicted. Educating parole commissioners about these issues is important. Volunteers and students at New York law schools help people in prison prepare for parole interviews. It is my privilege to teach law students and to supervise their work on these cases. It is important, deeply challenging, and extremely rewarding work. Students gain an appreciation of the criminal legal system that is not available to them from books. They consider policy in an entirely different context. When we meet our clients, it is often difficult to reconcile the person across the table with the person described in the criminal records and files. We begin by getting to know who that person is today, and then we move back to the beginning. We talk and learn about how they became the person who committed the crime. We gather school records, talk to family members and friends. We assemble the criminal record, review the trial transcript, and any other documents we can find in order to understand the events and our client's role in them. A picture emerges. We work through these details with our clients, many of whom are confronting them for the first time, or at least for the first time that they can remember. It is a long process. It is draining for us, and we did not live through it. It is not our story. Parole release is the goal for everyone who is eligible, but it is not the end of the story. Release comes with its own challenges: housing, employment, reconnection to family, friends, and the world outside. We are fortunate in New York to have a vibrant and engaged reentry community led by people who have lived that experience. They are invaluable partners who are leading and actively involved in every stage of the effort to achieve meaningful parole reform. Thank you.